Did you have rebuttal?
I do, Your Honor.
Okay. You may go ahead.
Screen. So you have attack prosecution's experts. That's one of the things you gotta take a look at. You gotta take a look at the credibility of witnesses. This is one of the instructions you're gonna get. Does a witness have any bias, prejudice, or personal interest on how a case is decided? And that includes the experts. That includes everybody here. So you wanna compare experts here. Let's compare for science. For science is not an expert entity. For science is an advocacy group for police officers. That's what they're there for. Bond cleaning, and that's their network. That's their whole thing. So you want to compare about why not to believe somebody. Why would you believe an entity that starts out with giving the benefit of the doubt to the officer? That was Von Kleem's testimony. He starts out. So how can you be impartial? How can you be coming from a position of neutrality when you start out? You're going to give the benefit of the doubt to the police officer, which goes into them finding 98% of the time officers acted appropriately. What other profession is that infallible? What other profession? Name one that they're correct 98% of the time. So that goes into how do you believe they're experts? Yeah, they paraded a bunch of experts out here. And it gives you just an insight of what happened. If you guys remember my question to Mr. Bartel. He said, well, geez, MMA goes 5 minutes, right? MMA goes 5 minutes. Well, that was the dumbest question ever made in the history of cross-examinations because the disdain from the stand just oozed out of his pores. How could you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, so whole years and blah blah blah. Yet the next day, when Von Kleem, his partner, his friend, who he presents with all the time, what does Von Kleem do in his report? Compares Patrick to an MMA fighter, because that's what they got to do. They've got to say the opportunity, he has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy group for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity. That was a tactical advantage because why? Because Von Kleem and Lon Bartels do jiu-jitsu and they do grappling. And so ergo, that Patrick has the same opportunity because he can suddenly spring up from a face down or a face on his back position and maybe use the taser. That's what gives him the opportunity. Von Kleem talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick is why you can think he's going to use deadly force. Von Kleem doesn't want to use that against police officers because they have no idea how can they come up with disproportion. They can't comprehend that. So when you want to talk about bias and prejudice against the experts, you want to criticize ours, take a look at theirs. And then they're comparing apples and oranges. Because our experts are use of force, they say, in terms of taser, what a taser does, what a taser can do. And it's possible for these things to happen, but it's not reasonable to think it is going to happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does it take Wegovy? You listen to all the bad things that can happen on any of the drugs that are on TV because they may cause, hair loss, liver problems, and so on and so forth. But they want to use that as justification because all this may happen. It could, the wires could. There is no, talk about distractions. There is no evidence the wires were broken. There is no evidence that anybody was feeling MMI. There's no evidence that wires had any impact. But they've got to throw out all these things. You want to talk about another thing? Why isn't GRPD? Why do we ask for GRPD? Does a bank, when somebody embezzles money, investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just GRPD, this is for anybody. How do you judge something that you trained? I mean, Captain Cybers said, hey, I was his commander at one point in time. You think they're coming from a position of not bias because you're asking to judge their policies, their procedures, and what this person does, they like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Cyber say? Because Captain Cyber, when we asked, we said, okay, you've been listed as a defense witness, okay, what's the policy? If somebody's disarmed with a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago, when the detective asked you about it, you said, no, there's nothing. But now that, as soon as somebody disarms you of a weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. Nope, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even then, and this is what I'm talking about, you can believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same. There's no difference. Both of them say that. So that to create this, he doesn't know what generally police practices are because he wasn't trained on them. It's just a fallacy because it's one and the same according to GRPD. But the other example is Officer Gady. Why couldn't he talk to the officer? No, I got better things to do. He doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try and shoot an arm off. They're not going to try and shoot a foot. That is, why didn't he want to talk to the detective about that? And so he trains, he was part of his recruit class. It's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or didn't he not sound like Seth Stoughton? Because he was worried. He said, yeah, we pulled up. I couldn't see inside that car. I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time, all with handguns drawn, and watch the body cams. How carefully they approach that car because they don't know. That's what they're trained. So it's kind of a contradiction in terms of saying, yep, it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policies that says don't do that you saw. That's a big difference there. How can you chase if they're treating everybody, 3 officers on scene being that careful? Why is 1 officer all by himself? That's okay. That's fine. And so it's not distraction. So what is the purpose of the reasonableness of the officer's actions when you're looking at the totality of the circumstances? If it's just as many times as you snap your hands, there's no totality of circumstances. It's just looking at that moment, period, and what's the purpose of the totality of circumstances, looking how the officer got into that situation. There is no purpose. There is no totality of circumstances. Well, he was somebody had a taser, you can shoot him. And the interesting thing was, because who did they say? Who did he say? Well, Professor Kroll is the one who said, oh yeah, they're able to use deadly force because he did that study. Professor Kroll isn't a taser expert. He has no idea of police policies. He said, that was his testimony, it was his impression of police policies. Because they can't bond clean, the GRPD officers, nobody can say anything about what the taser policy. There is no, take a look at all the policies, take a look at the policy where it says, if you're disarmed with a taser, you can use it. You can shoot them. Because it's not there. There is no policy. It's based on the totality of the circumstances, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser? That's what's not reasonable about all this. And you're right. You're right, manslaughter is gonna be brought up. And it was a complete misstatement of the law to say, well, the manslaughter is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they wanna kill him. It's not, well, they got into a fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody who's driven to kill somebody. That's what we're talking about here. It is not just, well, there was a fight they didn't mean to. That's a completely different thing. Manslaughter, listen to it. And because of emotional excitement to the point a reasonable person may have acted in impulse. And if anything, that's what their experts are talking about. That's what their experts bring up. Yeah, Professor Blake. Yeah. Heuristics. Heuristics, and I said, yeah, heuristics. It's kind of, putting in layman's terms, that means jumping to conclusions. And that's it right there. He doesn't know why he's running, so he jumps to a conclusion. The defendant jumps to a conclusion. Well, there must be something worse here. There must be something worse here. I'm gonna jump to the conclusion and think it's a bad thing. That reduces it, so it's justified, excused, it reduces it to a lesser crime. Manslaughter is a lesser crime, so if you think this fight, if you think this battle, you need to characterize it as a battle, because what it is a wrestling match. And that's in the totality of the facts and circumstances. How does somebody want to kill you when they don't do anything else before that? How do they want to kill you? What evidence do they want to kill you? He grabbed my taser, and I'm tired. That's not enough. That is not enough to justify taking another person's life. And watch the video. Yeah, take a look at the video. Yeah, he stands up 3 times, but at the moment he goes to push himself up, the defendant shoves him back down. He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. And why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. I thought the other thing that was, interesting about, GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put that's a serious weapon, but the fear of God in an instrument that you put the soundtrack to Top Gun to in a graduation video, and take a look, get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah, somebody's going through it again. It's taking the ride. We're talking about taking the ride. Yeah, it's a serious weapon, but it's not a weapon that's going to cause death or great bodily injury. That's not putting the fear of God into them when you put it to the soundtrack of Top Gun. It's not putting the fear of God into them when you're sitting there smiling at them, smiling at somebody getting tased. It's something you're concerned about, sure. But this whole thing in terms of distractions, it is once again, it's amazing now, because now we're saying don't ignore the defendant's prior statement, ignore it, because it was just a police report. But we heard on the stand that we couldn't trust his testimony on the stand either. Why? Because, Mr. Dodge asked him, well, it's been 3 years. There's a lot going on in those 3 years. You've been through a lot of trauma. So you can't really believe his testimony by his own, attorneys asking him questions, but then you're also not supposed to pay attention to his written statement, so how do you determine what it is? You gotta take it. That's what the statement's there for. Compare. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says in his written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Siren. Somebody may have a gun. That was a bladed statement. No testimony to that. It was in his written statement. And then I didn't ask him questions. Well, show us the bladed stance. Well, it's a different perspective. You really can't see. So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think you may have a weapon, you shouldn't be chasing them. That's what GRPD policy says. It's a bad idea to do that. And you've got to take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's going to kill you. That is not reasonable. It may reduce it. Maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, yeah, it's a big decision. But a reasonable doubt, you'll hear, I've talked about it before, a reasonable doubt is a fair, honest doubt, but it leaves you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that's presented here. I think when you look at this, when you look at the facts, when you look at the evidence, should be firmly convinced that there was a homicide here, there was a murder. It was second-degree murder. It was a death caused by the defendant. He intended to kill, and there is no justification for it. Simply having a taser with nothing more does not think, oh, I'm gonna die. We've had all kinds of people up here saying, yeah, we survived, we got tased numerous times, Vine Clean got tased in the head, he's still talking about it, lasts about 30 seconds. And even in terms of you want to talk about reasonable, yeah, use their expert, use Professor Kroll. It's never happened in the history of policing, where an officer's been tased, disarmed his weapon, and killed. And it's his impression that's because they kill. But the one thing where he said is it's happened 9 times where a person's actually been tased, an officer's actually been tased, but in the other case, the majority of the time, nothing happens. But they want to, every possibility consider, you have to consider what's reasonable.